So a federal judge just dropped an order that has Donald Trump's top advisors absolutely scrambling for cover, and what the judge is demanding could expose everything they've been trying to hide for months. Trump's legal team has been operating under the assumption that they could keep delaying, keep stalling, and keep hiding documents from the court. Whether it was classified files at Mar-a-Lago, financial records from his businesses, or communications about January 6th, the strategy has always been the same. Delay, deny, and hope something breaks their way before they have to actually hand anything over. But guess what? A federal judge just said enough is enough, and it's honestly hard to believe how direct this ruling is. This isn't just about Trump facing another legal setback. We're talking about a court order that demands full and complete disclosure of documents that Trump's team has been fighting to keep secret. This includes communications between Trump's advisors, financial records, and potentially evidence of obstruction. And trust me, the panic this is causing inside Trump's inner circle is unlike anything we've seen before. If you enjoy deep dives into political and legal developments that actually matter, make sure to hit that like button and subscribe to stay updated on this story as it unfolds. Let me fill you in on what's been happening behind the scenes and why this ruling has Trump's advisors running scared. So we need to talk about federal judge Tanya Chutkan, who's presiding over Trump's January 6 case in Washington, D.C. She was appointed to the bench in 2014 and has built a reputation as a no-nonsense jurist who doesn't tolerate delay tactics or procedural games. She's already shown in previous hearings that she's willing to push back against Trump's legal team when they try to slow things down. Now here's the situation. Trump's legal team has been using every trick in the book to avoid complying with discovery orders. For those who might not be familiar with legal terminology, discovery is the process where both sides in a case have to share relevant documents and evidence with each other. It's a fundamental part of how our legal system works. You can't just hide evidence that might hurt your case. The court can order you to turn over documents, communications, financial records, and anything else that's relevant to the case. But Trump's lawyers have been claiming executive privilege, attorney-client privilege, and every other kind of privilege they can think of to avoid handing over documents. They've argued that certain communications are protected, that some financial records aren't relevant, and that releasing various materials would somehow harm national security or violate Trump's rights. But here's where the rubber meets the road. Judge Chutkan wasn't buying any of it. After months of these delay tactics, she issued an order that basically said Trump's team has 5 days to produce a complete inventory of all documents they're withholding and provide specific legal justification for each one. Not vague claims about privilege, not general statements about confidentiality. Specific detailed explanations for every single document they're refusing to hand over. We're now looking at a situation where Trump's advisors, including people like Steve Bannon, Roger Stone, and various lawyers who were involved in the January 6th planning, are suddenly facing the prospect of having their communications exposed in court. Internal strategy memos could become public. Text messages discussing what they knew and when they knew it might have to be disclosed. Financial records showing who funded various activities leading up to January 6th could be revealed. This is all unfolding because the prosecution argued convincingly that Trump's team was abusing privilege claims to hide evidence. They pointed out that you can't just slap a privileged label on documents to make them disappear. There are specific legal standards for what qualifies as privileged communication, and Judge Chutkan agreed that Trump's team was stretching those standards way beyond their breaking point. And guess who's caught right in the middle of this? Everyone who was advising Trump during the period leading up to January 6th and afterward. They're the ones whose communications and actions are now subject to disclosure. Judge Chutkan is supposed to be impartial and follow the law wherever it leads. But here's the kicker: Trump and his team have spent years attacking judges, claiming bias, and trying to undermine public confidence in any court that rules against them. They want complete protection from legal accountability, and when that doesn't work, they attack the entire judicial system. And before we go any further, let's be real for a second. This case represents a test of whether our legal system can actually hold powerful political figures accountable when they try to use every procedural trick to avoid transparency. It's one thing for Trump to delay cases through appeals. It's another thing entirely when a judge steps in and says you have to stop hiding evidence and start being honest with the court. Now back to the matter at hand. Judge Chutkan's order was remarkably specific. She didn't just tell Trump's team to hand over documents. She told them they had to create a detailed privilege log. That's a legal document that lists every single item they're withholding, describes what it is, identifies who created it and who received it, states the date it was created, and explains the specific legal basis for claiming it's privileged. This isn't something you can fake or fudge. It requires going through potentially thousands of documents and providing detailed justification for each one. Reports from around December 12th revealed just how calculated Trump's legal strategy had been. According to legal analysts interviewed by CNN, Trump's team had been slow, rolling document production for months, hoping that delays would either cause the case to get pushed past the election or would wear down the prosecution's resources. They were essentially betting that if they could stall long enough, something would happen that would get them off the hook. Judge Chutkan's order labeled this strategy as unacceptable and said the court would not tolerate any further delays in document production. She pointed out that the defense had already been given multiple extensions and that there was no legitimate reason for continued delays. Talk about a judge who's had enough of the games. Essentially, Judge Chutkan was telling Trump's team that their delay tactics were transparent, that the court could see exactly what they were doing, and that it was going to stop immediately. She wasn't making some narrow procedural ruling. She was calling out their entire approach to the case as obstructive. And this wasn't a private conversation between lawyers. Judge Chutkan issued this order in open court, where it immediately became part of the public record. Legal reporters were in the courtroom, and within minutes, the details of the order were being reported by major news outlets. The judge made it crystal clear that Trump's team was on notice that their tactics were not going to work anymore. This announcement sent shockwaves through Trump's legal team because it raised fundamental questions about their entire defense strategy. If they can't hide documents behind privilege claims, what else do they have? The prosecution has already built a substantial case with the evidence they do have. If Trump's team now has to turn over documents they've been fighting to conceal, what's in those documents that they're so desperate to keep hidden? Now, this isn't the first time we've seen Trump and his allies use legal tactics to try to run out the clock or avoid accountability. The pattern of delaying, appealing, claiming privileges, and attacking judges really extends across multiple cases and goes back years. Trump's approach to legal battles has always been to treat the courtroom like a business negotiation where the goal is to outlast your opponent. In his business career, he famously used lawsuits as a weapon, filing suits against contractors and then settling for pennies on the dollar, or defending against lawsuits by dragging them out until the other side ran out of money for legal fees. Just think about how Trump handled the New York fraud investigation. When Attorney General Letitia James subpoenaed financial records from the Trump Organization, Trump's team fought the subpoena for over a year, using every possible legal argument to avoid compliance. Eventually they had to turn over documents, but they delayed that process as long as possible. Then there was the congressional investigation into January 6th, when the House Select Committee issued subpoenas. Trump claimed executive privilege even though he was no longer president. Steve Bannon refused to comply and was convicted of contempt of Congress and sentenced to 4 months in prison. Peter Navarro faced similar consequences. Trump's strategy was to encourage everyone to resist, delay, and obstruct, betting that political changes might make the whole investigation go away. And let's not forget the classified documents case at Mar-a-Lago. After the National Archives tried for months to recover presidential records, and after the FBI executed a search warrant, Trump's team still tried to claim he had declassified everything or that documents were covered by executive privilege. Every step of the way, the strategy was delay, deny, and muddy the waters legally. Now it looks like Judge Chutkan is confronting this pattern head-on and saying that it won't work in her courtroom. The rules apply to everyone, including former presidents. This pattern is becoming all too familiar to anyone who follows Trump's legal troubles. You can have a seemingly strong legal position, you can hire the best lawyers money can buy, and you can try every procedural tactic in the book. But eventually, when you're facing serious criminal charges in federal court, those delay tactics run into judges who have the power to say enough is enough and force compliance. So what did Trump's team do to provoke Judge Chutkan into issuing such a strong order? Well, it all boils down to their persistent refusal to comply with standard discovery procedures while trying to appear cooperative on the surface. The situation broke down like this. The prosecution needed access to communications between Trump and his advisors during the crucial period from November 2020 through January 2021. These communications are directly relevant to understanding what Trump knew about his election fraud claims, whether he was advised that those claims were false, and what his intent was in encouraging the January 6th rally and the march to the Capitol. That goes to the heart of the criminal charges against him. Trump's legal team, on the other hand, was trying to maintain control over what evidence came out and when. They claimed that many of these communications were protected by attorney-client privilege because lawyers were involved. They argued that some communications involved presidential decision-making and were therefore covered by executive privilege. They suggested that releasing certain documents might compromise ongoing legal strategies or reveal sensitive information. As the defense lawyers, Trump's team filed motion after motion requesting more time to review documents, more time to prepare privilege logs, more time to brief legal issues about what was and wasn't privileged. Each request seemed reasonable in isolation. But when you stepped back and looked at the pattern over several months, it became clear they were just trying to delay the trial date and keep evidence hidden as long as possible. At first, Judge Chutkan seemed willing to give Trump's team some benefit of the doubt. She granted initial extensions for document production. She allowed extra time for briefing on privilege issues. But as the delays stretched from weeks into months, and as it became increasingly clear that Trump's team was not acting in good faith, her patience ran out. But here's where things started to go wrong for Trump's legal strategy. As the case progressed and pretrial deadlines approached, the prosecution started filing detailed responses showing that Trump's team wasn't just slow in producing documents. They were actively trying to hide evidence. The prosecution obtained some communications through other sources, like testimony from witnesses who had their own copies of text messages or emails. When they compared what they had received independently to what Trump's team was claiming was privileged, huge discrepancies appeared. For example, Trump's team claimed that certain strategy memos were protected by attorney-client privilege. But when the prosecution showed that those same memos had been shared with political advisors who weren't lawyers, and that they discussed campaign strategy rather than legal advice, the privilege claim fell apart. You can't claim something is a confidential attorney-client communication if you shared it with half a dozen political operatives. The prosecution also pointed out that some of the communications Trump's team was trying to hide involved discussions of potentially illegal activity. There's a legal principle called the crime-fraud exception that says you can't use attorney-client privilege to shield communications where lawyers were helping plan or cover up crimes. If Trump and his lawyers were discussing how to pressure state officials to overturn election results or how to organize fake electors, those conversations aren't privileged legal advice. They're potential evidence of criminal conspiracy. This was the moment when Judge Chutkan's entire approach to Trump's team shifted. You see, federal judges value honesty, compliance with court orders, and respect for legal procedures. They don't appreciate being played for fools. When it became clear that Trump's team wasn't just slow, but was actively trying to game the system and hide evidence, Judge Chutkan had to decide whether to let that continue or to crack down hard. And then Trump's team made their fatal mistake in Judge Chutkan's eyes. They filed yet another motion asking for more time, using vague language about the complexity of privilege determinations and the volume of documents that needed review. But this time, they couldn't point to any specific new developments that justified another delay. They were essentially asking for more time just because they wanted more time. When Judge Chutkan read that motion, she had apparently had enough. According to legal reporters who were in the courtroom when she issued her order, her frustration was evident. She pointed out that Trump's team had been given multiple extensions already, that they had access to all the documents they needed, and that there was no legitimate reason they couldn't produce a privilege log and turn over non-privileged documents immediately. In Trump's world of operating above the rules and using legal procedures as weapons rather than tools for justice, this order from Judge Chutkan represents a fundamental threat. It means he can't just delay indefinitely. It means privilege claims will be scrutinized rather than accepted at face value. It means the evidence will come out whether he wants it to or not. Now, this left Trump's advisors in an absolutely impossible position with no good options available. On one side, they desperately need to prevent certain communications and documents from becoming public. There are likely text messages, emails, and memos that show they knew Trump's election fraud claims were false. There are probably communications discussing strategies to pressure state officials that would look terrible in court. There may be evidence of coordination with extremist groups that came to Washington on January 6th. All of this could not only hurt Trump's case, but could implicate the advisors themselves in criminal activity. On the flip side, they now face a federal judge who has made it crystal clear that she won't tolerate further delays or games with privilege claims. If they don't comply with the order to produce a detailed privilege log within 5 days, they risk being held in contempt of court. That's not just a slap on the wrist. Federal judges have the power to impose serious sanctions for contempt, including fines and even jail time. They could also rule that Trump's team has waived any privilege claims by refusing to properly document them, which would mean all the disputed documents have to be turned over immediately. The impossible choice these advisors face is that they can either risk criminal exposure by turning over documents that might incriminate them and Trump, or they can risk contempt sanctions by continuing to stall and refuse compliance. Neither option is good, and there's no third path that lets them avoid accountability entirely. So Trump's advisors are completely caught in this bind. They could try to continue stalling, but Judge Chutkan has made it clear she'll impose serious consequences if they do. They could try to be more aggressive in their privilege claims, but the prosecution has already poked massive holes in previous privilege arguments. They could try to appeal Judge Chutkan's order to a higher court, but that takes time, and the order has a 5-day deadline. Or they could actually comply with the order, turn over the privilege log showing what they're withholding and why, and accept that the judge will likely rule that many of their privilege claims are invalid and force document production anyway. But that means evidence they've been fighting to hide for months will finally see the light of day. It's a lose-lose situation, and that's exactly the position Judge Chutkan intended to create. She's making it clear that games and delays won't work anymore. The evidence is coming out one way or another. The only question is whether Trump's team will comply gracefully, or whether they'll force the court to impose sanctions before compliance. This whole scenario is causing major fracturing within Trump's legal and political teams. The people who've been advising him on legal strategy are now potentially exposed to legal jeopardy themselves. This creates conflicts of interest and breaks down the unity that Trump needs to mount an effective defense. If Judge Chutkan's order stands, and if Trump's team is forced to produce documents they've been hiding, every person mentioned in those documents is left wondering whether they're about to become the next target of criminal investigation. Communications that seemed routine at the time might now look like evidence of conspiracy when viewed by prosecutors and a jury. Those advisors who were trying to stay in Trump's good graces while also maintaining some distance from the most extreme actions are now worried sick about what might be in communications they've long forgotten about. Did they send a text message that could be interpreted as supporting illegal activity? Did they attend a meeting where criminal plans were discussed? Did they forward an email that shows they knew what was being planned? Meanwhile, the hardline Trump loyalists who were most deeply involved in January 6 planning believe that everyone should simply refuse to comply with court orders, fight every subpoena, and dare the court to impose sanctions. From their perspective, any cooperation with the prosecution is betrayal. They want Trump's team to take the most aggressive possible stance, appeal everything, and create a narrative that the entire prosecution is politically motivated. Things became even more tense when reports emerged that some of Trump's advisors were quietly reaching out to their own lawyers, separate from Trump's legal team, to figure out what their personal exposure might be. That's a huge red flag in any criminal case. When co-defendants or potential co-defendants start lawyering up separately, it suggests they're more concerned about protecting themselves than maintaining a united front. When people who were supposed to be Trump's most loyal defenders start worrying more about their own legal jeopardy than about Trump's political future, you know the situation has deteriorated badly. The fear that Judge Chutkan's disclosure order has created is rippling through Trump's entire circle. The legal requirements for a proper privilege log are well established. For each document being withheld, the log must identify the date, author, all recipients, a description of the subject matter, and the specific legal basis for the privilege claim. This isn't something Trump's lawyers can throw together quickly. If they do a sloppy job, Judge Chutkan will reject the log and order full production. The court process is moving quickly now because Judge Chutkan has made it clear she won't tolerate further delays. The 5-day deadline for producing the privilege log is extremely aggressive. That means Trump's lawyers are working around the clock right now, going through potentially thousands of documents. And let me tell you, the stakes of this order couldn't be higher for Trump's legal defense. If the documents that get disclosed include evidence showing Trump knew his election fraud claims were false, that undermines his entire defense strategy. If communications reveal detailed planning for January 6th, that could support charges of conspiracy. The judge's order calling out Trump's team for delay tactics is now part of the permanent court record. Every time Trump or his supporters claim the prosecution is rushing things or not giving the defense enough time to prepare, prosecutors can point to this order showing that Trump's team has been the one causing delays. Every time Trump claims he's being denied due process, the order shows he's actually been given multiple extensions and opportunities to comply. The significance of a federal judge directly confronting Trump's delay tactics can't be overstated. It sends a message to other judges handling Trump's various cases. It shows prosecutors in other jurisdictions that aggressive timelines and strict compliance orders can work. And it tells the public that the courts are taking their role seriously in holding powerful figures accountable. Legal experts across different perspectives have noted the unusual nature of how directly Judge Chutkan addressed Trump's tactics. Typically, judges try to maintain at least a veneer of neutrality and avoid language that seems overtly critical of one side. But Judge Chutkan's order didn't mince words. She made it clear that Trump's team's behavior was unacceptable and that it would not be tolerated going forward. According to legal analysts interviewed by MSNBC, this kind of direct judicial intervention is rare but not unprecedented in cases where defendants are clearly abusing legal procedures. When former Nixon White House officials tried similar tactics during Watergate prosecutions, judges cracked down hard. When Enron executives tried to delay their trials through procedural motions, judges set strict deadlines and enforced them. The legal system has tools to deal with defendants who try to game the system, and Judge Chutkan is using those tools. When legal commentators from across the political spectrum start noting that a judge's order is unusually direct and powerful, that's a sign that something significant is happening. This isn't just routine procedure. This is a judge drawing a line and saying that one of the most powerful political figures in America will be held to the same standards as everyone else. So let's break down what this legal order means, because it's not just dramatic courtroom theater. It has serious consequences for Trump's criminal cases and potentially for his political future. First up is the immediate legal impact. Trump's team now faces a hard deadline with real consequences. They have to produce a detailed privilege log within 5 days or face contempt sanctions. That means long nights for Trump's lawyers going through documents, and tough decisions about what they can realistically claim is privileged versus what they'll have to turn over. The order also limits Trump's ability to delay the trial date. One of his main strategies has been to push trials past the election, betting that if he wins, he can make federal cases go away. But now that Judge Chutkan has cut off that delay tactic, it's much harder for Trump to run out the clock. The trial will proceed on schedule, and Trump will have to face the evidence that's about to be disclosed. Now let's touch on what this means for Trump's political position. While his supporters see him as fighting against a corrupt system, moderate voters and independents understand that if you're accused of a crime, the evidence should be made public. Judges enforcing the rules don't look like persecution to most Americans. They look like the system working as it should. The real damage to Trump's political standing might come when the actual documents get disclosed. Once communications showing what he knew and when he knew it become part of the public record, his narrative gets much harder to maintain. If text messages show his advisors telling him the election fraud claims were false and he kept making those claims anyway, that's devastating. There's also a broader precedent being set about the limits of presidential power. Judge Chutkan's order makes it clear that former presidents don't get special treatment in criminal cases. They have to comply with discovery like any other defendant. Each time a court takes this position, it strengthens the precedent that presidents are not above the law. Looking ahead to how this plays out, it's clear that this disclosure order is going to have major effects on Trump's legal strategy and his political campaign. If the evidence that comes out shows clear wrongdoing, if communications reveal consciousness of guilt or efforts to cover up illegal activity, that's extremely damaging. Trump can call it a witch hunt all he wants, but when actual evidence is presented in court and made public, that's hard to spin away. The pressure on Trump's legal team right now must be enormous. They're working against a 5-day deadline knowing that whatever they produce in that privilege log could be picked apart by prosecutors and ultimately rejected by Judge Chutkan. Every decision about what to claim is privileged and what to turn over is fraught with risk. So here's the deal. A federal judge just issued an order forcing Trump's legal team to stop hiding documents and start producing evidence within 5 days, and that order has Trump's advisors scrambling because they know what's in those documents could be devastating. This isn't just about one more legal setback in one more case. It's about whether the courts can enforce basic rules of criminal procedure against a former president who's built his entire defense strategy around delay and obstruction. It's about whether documentary evidence of what Trump knew, and when he knew it will finally become public. If Trump's team complies with the order and produces documents that show criminal intent or knowledge of wrongdoing, then we're looking at a fundamentally stronger prosecution case. That would make conviction much more likely and would seriously damage Trump's political narrative that he's the victim of a witch hunt. It's about so much more than just this one disclosure order. It's about whether our legal system genuinely has the tools and the will to hold powerful people accountable when they try to use every procedural trick to avoid transparency and avoid facing evidence of wrongdoing. So keep an eye on this deadline. The next 5 days are crucial. Trump's lawyers are working around the clock, right now trying to figure out how to comply without giving prosecutors everything they need to convict. The privilege log they produce will tell us a lot about what they're most scared of disclosing, and Judge Chutkan's ruling on that privilege log will determine what evidence actually comes out. The stakes have never been higher, the pressure on Trump's team never greater, and the outcome never more uncertain. This is a defining moment in the case against Donald Trump, and the reverberations from this order will echo through his other legal cases and through the presidential campaign. If you want to stay updated as this story develops, and as those documents potentially get disclosed, make sure you're subscribed so you don't miss what happens next when that 5-day deadline hits. The evidence is coming and Trump's advisors know it,